Hi everybody, this is Amy Schwartz-Wallace from the Empire Justice Center. Welcome to today's webinar entitled How Attorneys Representing Domestic Violence Survivors Can Obtain ADA Accommodations in New York. Today's webinar will be 1 hour long. We are joined by some terrific panelists from the New York State Unified Court System who will be sharing what they know and the work that they do around us. I'll be having them introduce themselves, but I'm just going to do a couple quick orders of business. Today's program is a CLE, so I will be reading a CLE at some point during the presentation today. So please take note of that CLE code and write that down. You can receive all the attorney affirmation forms that you need and the evaluations that you need for CLE purposes in the handout bar. You'll want to make sure to include that CLE code in your materials because I will be, in order to get your CLE credit. So without further ado, I'm going to turn the controls over to Monique Taylor from the Unified Court System to begin introductions for today's program. I do want to say that if you have any questions, we'll be planning to take questions at the end. I'll be monitoring the questions throughout the program, and you can simply type your questions in by opening up the questions bar, and there'll be a little area for you to type your questions in, and we'll be addressing those throughout. But I will be monitoring the questions through the program. So sorry about that, Monique. I'm turning it over to you officially now.
Good afternoon, everyone. My name is Monique Taylor, and I work for the Division of Professional Court Services. Okay, the PowerPoint was not working at first for some reason. I work for the Division of Professional Court Services, and I am a management analyst, and I serve on the ADA team. And joining me today, we have some wonderful, my wonderful colleagues. We have Dan Weitz, who is the Director for Professional Court Services. He is also the ADA statewide coordinator. We have John Sullivan, who's the Assistant Deputy Counsel who works for our counsel's office. Amy Pantillo, who is our senior counsel, who works for Professional Court Services. Now, what do we do at OCA? Under the Division of Professional Court Services, we are responsible for addressing inquiries regarding concerns under the Americans with Disability Act. We assist courts in assuring access to services and reasonable accommodations for court users who qualify under the ADA. Now, with that said, I would like to turn it over now to Dan Weitz, our Director and statewide ADA coordinator. Dan?
Thank you, Monique, and welcome everyone. And as I title of this is how attorneys representing domestic violence survivors can obtain ADA accommodations in New York court. So on behalf of our team, I also just wanted to thank everyone for the hard work that they do. We're very familiar with the work that advocates for victims of domestic violence do, and we encourage you to keep up the good work. We're honored to be presenting to you today. So on this issue of the Americans with Disabilities Act, what is the ADA? It's a federal civil rights law that protects qualified individuals with disabilities from discrimination based on their disability. Title II of the ADA applies to programs, services, and activities of state and local governments, which includes the judicial branch, which is us, the Unified Court System. And that includes not just litigants or people with cases pending in the courts, but all members of the public entering the courthouse, visitors, and others. Folks often ask, well, what is a disability? And that is, in fact, defined by the ADA. A disability is a physical or mental impairment that substantially limits a major life activity such as walking, seeing, hearing, learning, breathing, caring for oneself, or working. The ADA also protects people who have a record of such an impairment or who are regarded as having an impairment, whether or not they actually have one, if being perceived as having one results in discrimination. So that's a broad overview of the ADA and Title II, which is what implicates the judicial branch and the court system. Before we move on, does anyone else on the ADA team have any comments they wanted to make about that?
No, I don't have any.
We'll take that as a no. So under Title II, what is the Unified Court System's responsibility? We obviously have a commitment to ensuring that all qualified individuals have equal full access to the judicial system, and we operate our services, programs, and activities in a manner that's accessible to and usable by qualified individuals with disability. One of the ways we break this down is in two different types of accessibility issues. Maybe one of the more obvious is physical. You can see pictures there of accessibility ramps and accessible elevators and so forth. So there's an obligation under the ADA to ensure that people have access to the physical structures of the buildings, that they can get into the buildings, they can navigate within the buildings, that restrooms are accessible. But that also includes, you know, if they can't get into a particular courtroom where there's a hearing or into a clerk's office, for example, that we would actually move our services and programs to a floor where they would be accessible. And programs and services and activities also include, you know, things that have to do with, for example, court hearings. There might be certain disabilities where people might need extended breaks, and proceedings might need to be altered to accommodate folks. So the services, programs, and activities have to be accessible and usable to qualified individuals with disabilities. Before we move on, does anyone else on the ADA team to that?
Yeah, John, I would just point out that there's actually kind of an interesting bifurcation of responsibility between us and the localities that are responsible for providing under the judiciary law suitable and sufficient courthouse facilities for us. So when there's an issue having to do with physical accessibility, like the doors to the courthouse, the ramp to the courthouse, steps, anything physical within the courthouse, such as you know, elevators or restrooms, the responsibility for making sure that those are ADA accessible rests with the locality that provides the courthouse. So we work with localities as much as possible to make sure that that's the case, but we don't ourselves have an independent responsibility to make sure that courthouses meet ADA standards.
Thank you, John, and that's a great clarification. So in terms of the advocates who are out there, sometimes they may come across something. They can always, and we'll go through it, you can always get in touch with us, but understand that the responsibility for certain aspects might fall on a municipality as opposed to the court system. So we work very closely with municipalities. There could be confusion out there with regard to who's responsible for what. So another major aspect of what we do here is help provide training and assistance to what are called ADA liaisons, that in each judicial district there are appointed specific personnel who serve as ADA liaisons. They're largely facilitators to the public. If people want to request accommodations, they can reach out to an ADA liaison to make such a request for accommodation. They also provide an enormous amount of information about and arrange for the use of appropriate aids and devices. Quite often people want assisted listening devices and other forms of accommodations, and the liaisons can answer and help guide the public in how to go about making such requests. We publicize their presence on the court's website, on the frequently asked questions part on the website, so people can find a county listing of all the local ADA liaisons with contact information. We've updated that list recently. We do it on a regular basis. There are voicemail boxes that we're ensuring are there, so if people can't answer the phone, they can leave messages. We disseminate lots of ADA information to employees. We do webinars like this on a quarterly basis throughout this, for ADA liaisons throughout this, the unified court system. And they're also obviously available to assist judges and judicial officers when questions come up. So we'll get into, there's a difference between accommodations that are within the judicial role and have to be approved by judges, can be approved administratively by chief clerks and district executives. But these liaisons can end up being helpful to judges regardless of the nature of the request. But as I was just saying, that the ADA liaisons do not have the authority to deny an ADA accommodation. So someone who in need of an accommodation might make the request to the liaison, but that's something that falls to the chief clerk or district executive. They do not have the authority to deny ADA accommodations. Anyone on the team want to add to that before we move on?
I think I would just like to add some of the ADA accommodations that we do grant. You stated assistive listening devices. We also have qualified sign language interpreters, video remote interpreters. We have real-time computer-aided transcription services, which are known as CART, real-time captioning, written notes, note takers, written materials, relay services, accessible websites and information technology, recordings, braille or large print materials, qualified readers, and screen reader software. Other accommodations assist, we can assist with filling out court forms, permitting the use of a service animal, parking for people with disabilities if the facility provides public parking, and relocation of a proceeding to a different courtroom. So I will move to the next slide.
Hi, this is Amy. I'm sorry I'm jumping in. I would never be good at Jeopardy because I can never get this unmute thing done. Also, we provide training for court security, court officers. So in addition to those options, we do train our frontline security about things like service animals and other accommodations that can be made at the door to the courthouse.
Thank you both, Monique and Amy. That's a great list of the range of accommodations we typically provide. You should also know, and Monique, if we could go back to the previous slide just for a second too. You should also know that there are things that are required under the ADA. Our approach is typically to try to accommodate regardless of whether the ADA requires it. We're not going to necessarily put someone in a better position than they would otherwise be without the disability. But it's usually a flexible process, and we just try to accommodate without necessarily analyzing the ADA to determine whether or not it's a requirement. The pictures that are included in this slide, I think, are meant to indicate some of the informational materials that we use to educate liaisons and other court staff. So we're constantly amending them and revising them, but most recent versions of it sort of spell out that range of accommodations that Monique and Amy were walking you through, and those are things that are distributed to the courts. And kind of like judges have bench cards on certain things, non-judicial staff as well as judges can have that information at their fingertips as well. We're about to jump into maybe one of the more complicated issues, which is the difference between judicial and administrative. And that would be
Hey, Dan.
Yes.
Dan, this is Amy. I just want to remind our listeners that I saw a few hands raised in the features, and we are taking questions. Please type any questions you to the question pane, and we will be addressed either during today's webinar or at the end of the webinar. So please be sure to, if you have a specific question or point that you want to make, please use the question feature to put that in.
Yeah, thank you. Yeah, I could
Dan, can I jump in for a moment if you need? I think let them know how can ADA requests be made. We know that it's made to the liaison, but it can be made orally, in person, in writing, or by telephone, or email, or fax. So I just wanted to make sure that the listeners are aware of how they can make this request.
Sure. Well, just as you said, ideally things would be put in writing because it documents things and promotes clarity. But there's a lot of flexibility there, and the request it can be made in all those different formats that Monique mentioned, and it's made to the liaison. But as we said, ultimately, the liaison does not have the authority to deny the accommodation. So the overwhelming majority of requests for accommodations get accommodated. And on the rare occasion when it's going to be denied, that's done by the chief clerk in New York City courts or by the district executives outside of New York City. And I think the next slide that covers judicial versus administrative goes through some of the details of how those procedures are handled. Monique, is there anything else you wanted to add on that, the issue of how to make requests?
No, thank you, John.
Great. So we're going to try to handle this as a team because it is somewhat complicated, but I think we'll try to simplify it first. And then, yes, if people have questions that can't wait till the end, this is probably the slide that it happens on. So the administrative requests, as we said, the liaison serves as a facilitator. The liaison cannot address ADA requests that impact a judge's handling of pending court proceedings. So, you know, for example, if someone has a disability that requires them to start proceedings later in the day, or someone has a disability that requires them to take frequent breaks, that is something that obviously impacts a judge's handling of pending court proceedings, and that is a request that has to be made before the judge. And it is the judge's discretion and determination to be made. So that falls on the judicial side. But obviously when, if someone wants, I think even things like assisted listening devices and things like that, those are the kinds of things that can be handled at the administrative level. If someone is having you know, issues that don't impact the judge's handling of a pending court proceeding, those are sort of administrative requests. Does anyone, John or anyone else, want to sort of give other examples of sort of clear administrative requests as opposed to judicial ones?
Another judicial request would be appearance by telephone or by video conference. That would be under the discretion of the judge, and that's not an administrative request, but it would be the judicial ruling. Other than that, I think we covered everything else as far as assistive listening devices, you know, real-time reporting. That is obviously administrative, but if it's before the judge and it impacts the case, then it's up to the judge. Would you like to add anything to that, John?
No.
Okay, great.
So Monique mentioned CART, you know, computer-assisted real-time translation and things like that. A lot of those technological things are the kinds of things that could be handled through the liaison and the clerk's office, not necessarily requiring the judge's approval or decision. But obviously that goes back to that previous slide where the liaison sort of worked with the judges to coordinate these kinds of things. As I said, if someone is making an administrative request, they want an assisted listening device, they want those kinds of things, the overwhelming majority, they're going to get them, and the courts will help work to try to access those services. If it is going to be denied for reasons that are permissible under the ADA, that's something that has to come from the chief clerk or district executive in consultation with our office here. Specific form that they use, a denial of accommodation form. If that denial actually happens, there is a review process. The person who received the denial can request a reconsideration, and that goes to our office here. And there's a you know, that should be in writing, and it's delivered to us. And there are certain deadlines. I believe 30 days from the denial. Someone correct me if I'm wrong on that, but I believe it's 30 days from the denial, and then it can be reconsidered. If it's a judicial request, if it's a pending case before a judge or judicial officer, and it requires a modification or otherwise affect the court's practice and procedures, then the request has to be made to the judge or judicial officer. Again, that should be in writing, but there, you know, it can be done in the forms of motions, or liaisons can help people to figure out how to make those. But again, since it's a judge's determination, the denials are on the record, typically on the record in an order or other writing, but to be clear, not the same denial of accommodation form that's used on the administrative side. Obviously, if the request for judicial accommodation is denied, then the appeal process for that denial is the normal appellate process for any other judicial decision. So we know that it's it's not as straightforward as we would hope it's going to be. I would still, we're going back and forth on the PowerPoint, but that's, we distinguish those things, and those are the typical questions that do arise, that someone might make a request to the liaison and expect, with the liaison's help, the chief clerk or district executive could approve the accommodation or would deny it, but it's actually a request that must go before the judge. And then it's just simply working with the individual with disability to make that request of the judge and have the judge make the determination. Obviously, if there's a denial, then there's questions about what is the appropriate role for review of that. And again, if it's administrative, it goes up through us here at OCA. And if it's a judicial accommodation and denial, it goes to the normal appellate process. Sometimes advocates and individuals with disabilities are confused, and there's a judicial denial, and they come to us wanting us to do something. They want us to overturn it or review it, and that's clearly outside the scope of our abilities. The Office of Court Administration does not overrule judicial orders. That's something for the appellate division and appellate courts to do.
Dan, we did have one question. This is Amy at Justice. I don't know if you can entertain it. I think it's a quick.
Sure. Give it a shot.
If a request for ASL interpreters wants a team of 2 interpreters for a longer proceeding, is that an administrative decision or is that to the judge? I'm
sorry, I couldn't hear the question. The muting and unmuting was sort of interfering.
Oh, sorry. Okay. The question is, a request for ASL interpreters wants a team of 2 interpreters for a longer proceeding. Is that an administrative decision or referred to the judge?
I'll let John answer that in the first instance.
Yeah, that's it. That's going to be handled administratively. But obviously, once you're in the middle of a proceeding, if it's not done in advance, if the request is not made before the judge takes over the case, then the judge is going to obviously have to be involved because there's going to be some logistical issues to deal with to make sure that 2 interpreters are available at the same time and for the length of time that it will be needed. So that's a case where the liaisons would work with the judge, but it's basically that we generally look at the provision of interpreters as an administrative issue.
Thank you.
Are there any other, I know this is somewhat complicated, so if people do have specific questions about this, distinguishing between administrative and judicial, we could take those now before we move on to non-apparent disabilities.
Great, and I just want to remind our presenters, there's a bit of feedback on our end as listeners, and it's definitely impacting the listening ability. So if you are on a speakerphone, if you could just make sure to be speaking right into it or just pick up your receiver. I know we have people in different places. So a little clearer. And I will, I don't have questions at the moment besides the one we just answered. So if you want to move on, we can address those later.
Sure. Yeah, we can always come back to it. So that's the administrative role versus judicial role.
Thank you.
The next slide is on non-apparent disabilities, and it's definitely an important topic. People tend to think that folks with disabilities have apparent disabilities. They're in wheelchairs, they're wearing dark sunglasses, and they can't see, or they're walking with canes and so forth. But there are a large percentage of individuals with disabilities have non-apparent disabilities, whether it's things like post-traumatic stress disorder or other disabilities that wouldn't be visible. And oftentimes people might appear a bit off. They might have balance issues. So someone might assume that that they've been drinking or that they're high or something like that, but they could have a disability. It could be vertigo or other things that have caused that kind of affect. So it's very important training of our liaisons to understand the range of non-apparent disabilities so that we can be sensitive to it. And oftentimes people with non-apparent disabilities may not be comfortable even asking for an accommodation. We do have to educate and let people know if you don't tell us about your disability, we can't help you. But if they're not confident that their disabilities will be accommodated, then they might be reluctant to share it. So it's a big educational issue, and the more we can all learn about it from us in the courts to you as advocates, the better off we all are. If someone's got a disability, apparent or not, they have to let us know, and then obviously we will do everything we can to accommodate them, whether the ADA requires it or not. Does anyone else want to, Amy, you want to add anything on non-apparent disabilities before we go into some examples of accommodation requests and scenarios?
No, I mean, I think that we're going to touch on it a little bit when we get to the next scenario. But, we do train our officers and the liaisons about non-apparent disabilities, but also, for service animals, somebody might come to the court, it doesn't appear that this person has a disability, but they have a dog with them. So we do train, we do teach the staff and security that, it may not be obvious that this person has a disability, and we're going to go into like what questions security can ask if they're not sure if the person has a disability, but they come to the courthouse with a dog.
Great, thank you. So here are some examples of accommodation requests. In this scenario, the court received a letter from an ADA advocate in a divorce proceeding claiming that the plaintiff has PTSD and is requesting the following accommodations. Permission for the ADA advocate to sit with the plaintiff during the hearing. They ask for additional time to process the information. They ask for frequent breaks because of the stress. They ask for someone to take written notes for them, and they want free transcripts of the proceedings. So yeah, these are all examples of the kinds of requests that folks might make, and typically the kinds of accommodations that we might make. Although, John, I wonder if you want to comment on any of them and whether free transcripts of the proceedings is something that would typically be accommodated.
Yeah, that generally you would not get a free transcript because it would be accessible to you in the same way it's accessible to anybody else by paying for it. All of these requests here, I think, are requests that ADA liaisons would be involved in only indirectly and at the request of the judge. All of these requests would be of the sort that would be made to the judge, him or herself, because they would affect the way the proceeding is being handled by the judge.
Right, so 1 through 4 are all the kinds of requests that would typically be accommodated, but they are for the judge to determine. But number 5 is not necessarily something that would be accommodated because of the parameters of the ADA. Anyone else on the team want to add anything to that?
No, I have nothing to add.
Okay. So in this next example, scenario 2, a litigant who has diabetes reports to the court for her hearing with a service dog. It's not apparent that she has a disability. So Amy began touching on this. She stopped the magnetometers entering the courthouse because of the dog. All right, so even in that instance, she may be stopped at the mags entering the court because of the dog, but there are limitations on what court officers are permitted to ask, and there's specific instructions that we give them about handling those situations. Amy, you want to go over that?
Sure. So under Title II of the ADA, the Department of Justice put out guidelines for service animals. So if it's not apparent what the service animal, the dog, is there for, accompanying the person, security staff may ask whether the service dog is required for a disability. They're going to listen for a yes or no answer. If the answer is yes, they can go to a second question, which is, what work or task has the dog been trained to perform? And here they're going to look for something specific, a specific action or response. So for example, for people who are suffering from post-traumatic stress disorder, it could be something like, you know, my dog senses when I'm going to have an anxiety attack, or if I'm getting agitated about something. My dog then can provide cover for me and apply deep pressure to help calm me. My dog can help me get out of the situation that I'm in. You know, and in the case of some dogs can be trained to remind people to take medication. So these are all things that we provide training for, to have our staff listen for.
Thank you, Amy. And this might be going deeper than we had planned, but I think you have said in the past that of service animals, what types of animals are recognized as service animals?
So under Title II, the guidelines say that it's just dogs, except there are separate guidelines for miniature horses. Miniature horses are probably about the size of a Great Dane, and there are separate requirements that have to do with size and safety that have to do with the mini horse. It doesn't come up as often, but you know, we do let our staff know that could happen, but it's going to be a dog, and it can actually be any kind of dog, any kind of breed, any kind of size. We're not just looking for the, you know, fluffy golden retriever or the golden doodle. We know that it can be any type of dog.
And Amy, what happens if the service animal is not under control?
So service animals have to be permitted in any part of the courthouse that members of the public are allowed to go in. And we instruct staff that the dog should not be separated from the person with a disability, because the dog is there to assist the person with the disability to do something that that person can't do on his or her own. But if for some reason, if the dog is not under the handler's control, that's either by a leash, harness, or tether, or by voice or hand controls. You know, so if the dog is, you know, is barking a lot or is aggressive, the handler can be asked to have the dog removed from the courthouse, but the handler has to be permitted in the court and to take part in the court proceedings without the dog present. The dog also has to be housebroken, and if for some reason, you know, the dog is having a problem with that, that's another reason why we can ask for the dog to be kept outside of the court.
The other thing to mention, Amy, is that dogs don't need any particular papers to demonstrate that they've been trained, certificates or anything like that, and it doesn't matter if a dog is wearing a vest that says service animal. If it actually hasn't been trained to perform a specific task, then it doesn't meet the definition, regardless of its wearing a vest that says service animal on it. So that's why court officers will ask those questions, and that should end the inquiry at that point. If a dog has been trained to perform a specific task, and it's a task that's necessary to the occasion, then the dog should be allowed in. We generally don't allow in, except at a judge's, you know, perhaps discretion, but it's not required under the ADA to let in an animal of any kind, including a dog, that's simply referred to as a comfort animal, that's there to make the person feel better because of some emotional attachment to the animal, as opposed to a dog that's been trained, as Amy mentioned, to perhaps to relieve anxiety in a particular way. But someone who's just there as a comfort animal, or a dog rather, that's just there as a comfort animal is not permitted to enter the courthouse. Generally, although a person wishing to bring a dog under certain circumstances that didn't meet the definition of a service animal could ask the judge whether the judge would permit the animal in the courtroom.
Thank you for clarifying that, John.
We've done training sessions with the liaisons specifically on issues of service animals, and we just touched on it there. So now imagine they've got everyone's handled their jobs properly, and they've gone through the magnetometers. They've entered the courthouse. This litigant is now before the judge and requests the following: a private area to test and administer insulin injections. This strikes me as an administrative request. And be made to the liaison, and obviously the liaison can make arrangements for there to be a private area for testing of blood sugar and insulin injections. Anyone on the ADA team want to add anything to that?
Right. It might be the case that the first time the need for an administrator becomes apparent is when the case is before a judge. But as you point out down here, this is really in the nature of an administrative accommodation, and the judge could simply refer this to a clerk, the clerk of the court, or a liaison to address.
Right. Yeah. It has to do with the phrasing of the question. In practical terms, this is something, as you point out, would be handled administratively, even if they are before the judge. But now, of course, they want this litigant wants breaks to test levels and administrations. That obviously impacts the way the judge handles the proceedings. So that requests can be made to the judge, and within the judge's discretion, they would allow those breaks. And typically, under these circumstances, the breaks would be allowed. Anything else to add to that?
No, not.
Same thing goes to permission to have food and drinks and food and water with her. That's something that, if they're before the judge and that's going on in the courtroom, probably the judge would want to sign off on that, but in all likelihood, that would be approved as well. And one of our final examples, imagine a member of the public, possibly a litigant, is waiting on a long line to enter the court. He appears to be uncomfortable. When a court officer asks the gentleman if he's okay, he states that he suffers from terrible back pain and standing in line is affecting his back. I don't know if people are muted or not, but we sort of wondered what people would expect or hope to do in an instance like this.
Dan, folks are muted.
Okay.
We can use the chat for people to answer that question. So I would just direct everybody to the chat feature, and feel free to type your answer in and hit respond to all / entire audience. Give folks a minute or two to.
I could prime folks and say how many think that that this member of the public should be moved to the front of the line, or is there another alternative, and go from there. So we have a move to the front of the line. We could have a lot of answers here, right?
Okay. All right, we're not getting any response. Next time we'll build in a... Oh, no, I see one or two. We'll move to the front of the line. Great.
So, here's possibly where our empathy overdoes it a bit. So moving the litigant to the front of the line actually puts the litigant in better position than others, without the disability. But what could be done, and what would likely be done, is you could bring them a chair so they don't have to stand in line. You could hold their place in line for them and have them go wait elsewhere. But under the ADA, the idea is that we don't move them to the front of the line and give them better access to the programs and services and activities of the court system, provide they get equal access to participate meaningfully. So I hope that makes sense to folks. Don't know if anyone else on the ADA team wants to comment on that.
Yeah, I just want to address one person asked or suggested that there should be an inquiry as to whether the individual is a litigant or a witness, and that brings up an interesting point. In terms of providing accommodations from the court system's point of view, it doesn't matter whether the person is there as a litigant or is there as a witness or it's just a family member or a friend. If they're there to participate in some way, they're entitled to an accommodation. So we don't really need to know what capacity they're there in if they need help. I think you mentioned the two other scenarios, Dan, that would enable them to be treated equally, but still have their condition accommodated.
Very, very helpful. I think there was also, I might have seen it, it sort of collapsed on my screen, but someone was suggesting perhaps a wheelchair, which common sense would say that would be a nice thing to do. The ADA does not require the court system or providers to provide medical devices and things like that. So our frequently asked questions on our website even says that we would not provide wheelchairs. I think obviously if a particular courthouse had a wheelchair available, they might try to do that to make things easier for people, but it's not something required under the ADA. So I think that is all of the substantive content that we wanted to make sure we covered. Which actually makes sense. It leaves about 15 minutes for questions and answers. I think we were going to pause here for a moment, though.
We are. To give folks the CLE code, I will do it right now verbally, and then I will type it into the chat feature and the question feature so folks can see it. The CLE code for today's program is 52467. Again, the CLE code for today's program is 52467. So please make sure to put that in the attorney affirmation form that you'll be submitting for CLE credit. All right.
Before I open it up to the questions, I just want to show you where you can find our ADA web pages on the public site. If you go to nycourts.gov, this screen would appear. You would scroll on Accessibility ADA, and that will take you to our ADA site, where we have a wealth of information for the public. It takes and walks through the court users how they can obtain ADA accommodations. We have frequently asked questions that answer so many questions. It's a great informational tool. And when Dan spoke about our local ADA liaisons, we have a page dedicated for that, listed by county, and you would just click on the county and the liaisons would appear. We are in the process of reformatting this page, and hopefully you'll see that within the next few days or so. But make sure if you have any questions, go and review our pages. It has a wealth of information. Now go back to the slide and open it up for questions.
So Dan,
Yep.
I was just going to, this is Amy, I was just going to read the question that was in the questions box about how someone can request an accommodation when they're interacting with other agencies that may be necessary as part of a case. So for example, a judge orders ACS to do a COI, and litigant is deaf and requires ASL interpreter to communicate with ACS caseworker.
Did you want me to address it again?
Either Dan or John, I guess.
Well, Dan, they have something to do on this. In this case, the provider of the service is ACS. And so ACS would be responsible for making sure that an interpreter was available in that interaction with the court user and between the court user and ACS. So that would have to be something that ACS would make arrangements for, even though it was a court-mandated meeting. Dan, do you agree?
Yeah. So, and so I know they're having trouble with our speakers and so forth, so some comes in and out. But if we're saying that if it's a service that's being provided through ACS and other agencies, it would be ACS's responsibility to provide the accommodation.
Yes. I think we can move to the next question, Amy.
Yep.
Sorry. Oh. I don't know which Amy.
Amy Pontella.
Which basically means that you have to be able to demonstrate that they have a disability, that they have a diagnosis. You know, that's going to be that you're going to have to present some evidence of that to the judge if the judge has any question as to whether or not the person has the disability that they assert they have. It's tough without a diagnosis for the judge to say you're entitled to an accommodation as a disabled person if they haven't seen a diagnosis. And that brings us to an important point that I don't know if we've touched on this, but you know, the court is allowed, both administratively and judicially, to ask for some medical documentation of the existence of the condition that the person asserts they have. And in particular, a lot of times where it's a diagnosis and it's not clear immediately what kind of impairments the person has and how those impairments connect to how they can participate in the proceeding. It's very important for the court or us administratively to have some understanding from a medical professional of what the person's limitations are exactly so that we can meet those limitations. So it wouldn't be unusual for a judge or for us to ask for some kind of medical documentation so that we can understand what was needed. With respect to, you know, affecting their ability, that may be a condition that whether or not that should affect the way a judge views the case would be up to the judge. You know, how to take that into account when sitting as a finder of fact. You know, requiring additional time, again, that would be up to a judge to decide. I assume you're asking whether they may need additional time to answer a question. It may take them a while to the question. I think most judges, in my experience, are more than willing to accommodate anybody who's testifying and let them take it at a pace that they need to take it at. May need questions asked in a leading way. That the courts may look upon that kind of askance, because then you're really implicating the rights of the other party in the action, and it may change the nature of the proceeding in a way that the ADA does not require an accommodation to do. I don't know if you want to add anything to that, Amy.
No, that's very thorough. Thank you, John. So I guess I'll go to the next one. And I think you may have answered this or touched on this next one. So same kind of situation. The client has PTSD from domestic violence and physically gets sick. She wants to know if the client has to appear in the courtroom with the adversary on a custody or family offense case. And we have heard questions like this before.
John, would you please turn?
Again, that's going to be up to a judge to make a determination about and weighing the rights of the parties. There is this right to face your accuser. So there may be, with the right showing of the need for this, you might be able to arrange for some kind of less direct contact between the parties. But the judge will have to weigh the rights of the parties on both sides in that case.
Okay, thank you. So that's another thing that would be up to the judge. And
right. There's also one other thing I should mention is there's also it's kind of difficult for a judge to have to prejudge an ultimate issue in the case in the guise of whether or not an accommodation should be made. So if there's a dispute over whether or not domestic violence has led to post-traumatic stress disorder, if that's part of the controversy to be determined, that's going to have to be handled with a lot of nuance by the judge, because you're basically putting the judge in a position of perhaps prejudging the merits of the case by asking for the particular accommodation.
Yeah, and I was just going to add, if you didn't already say it, John, that there are a lot of things that the judge can do. There are frequent breaks and otherwise monitoring things. But I think, John, you hit it, right on point when you were saying that regardless of how we all might understand and know the situation, that the judge has to balance the various rights in the courtroom. So. Confronting accusers and things like that might prevent the completely separate appearances.
Right. I should say also that there are cases where someone is unable to come to court for not necessarily because of the trigger of an adversary in court, but because they have agoraphobia or something like that, and that one and a reasonable accommodation in that case might be to allow for telephone or video appearances. But again, that would be up to the judge to determine at what juncture of the proceeding that would be possible.
Okay. Thank you. So the next question has to do about refers back to the question about working with other agencies, the ACS question. So does that answer about ACS also apply to private providers? So for example, in anger management classes.
Yes, I would say same answer there.
Same answer. Okay. So the next question, I don't know if this one refers back to I don't know which question this refers back to, but it says, does this also apply for 18B attorneys appointed by the court? Who is responsible to provide the accommodation, the court or the 18B panel?
John?
Well, I'm not sure what for the 18B attorney, once they're representing a client, has to arrange if the disability is on the part of the attorney and they need to communicate with their clients, they need to arrange for that communication. Or if their client it has the disability, then and it's just an attorney-client conversation, it's on the attorney to provide the accommodation that would enable the attorney to communicate with the client. It's only in the court setting that the court has to get involved with providing an accommodation.
Okay, thank you. So then the next question is assigned counsel for individuals with cognitive and or mental health related disabilities on matters that normally would not entitle one to assigned counsel. Assistance prior to bringing the matter to court. What is the best practice to request the accommodation? So I guess, is that an administrative or a judicial request?
Well, assignment of counsel is going to be one for the judge to handle. And in that issue, I'm not sure prior to bringing the matter to the court. I'm not sure what that contemplates. I guess someone could go to court on the person's behalf and ask for a guardian ad litem to be appointed to assist the person. But it's going to be a judicial determination depending on whether generally the courts take the position that a disability does not entitle you to assignment of counsel unless you otherwise qualify for it as a pro se person in the appropriate situation.
Right. Okay.
Looks like we're out of time.
Oh, okay. We had one more question. I don't know if we should, I'll ask the moderators what we should do.
You have one more question?
There was one more question on there. I think it might have been a clarification of the 18B question. If an 18B attorney refuses to provide an interpreter for attorney or client needs, where should a complaint be directed? Meaning outside of court proceedings. I don't know. I'm not familiar really with how that works with the 18B panel.
Seems to me to be a violation of the attorney, representation standards, and would probably be a complaint, an ethics complaint. Might also perhaps even be, would it be a complaint to the Department of Justice, perhaps, as a violation of their rights?
Yeah, I'm not sure. I was trying to speak before. I'm not sure if I got in there or not between unmuting myself on the system. But if it's the ATB panels and it's a question of their compliance with the rules, one of the avenues is to go through the appellate divisions who oversee in the different departments that oversee the ATB panels. If it's not if not to the grievance committee, it's not an ethics.
And I will just know that there was through the Department of Justice administrative decision, an attorney accountable for violating a deaf victim of domestic violence's rights to effective communication, and that attorney, I think, got a fairly significant fine. It was in Rochester. His name was Greg Tyrone. You can just Google that, or we can try to provide it later, but it's probably way quicker to Google that. But Greg Tyrone was cited by the Department of Justice for such a violation. Again, he wasn't an 18B attorney. He was private counsel, but I don't think there would be any difference.
Yeah, I would agree. I think that the DOJ would be one place to bring a complaint. And I think most of these 18B panels have an administrator, so that might be also a place to bring it. Not that they could direct the person, but it might be resolved by the participation of the 18B panel administrator.
And just to confirm, John, when you're talking about the 18B panel administrator, you're referring to those appellate division.
Yeah. I'm not sure how to organize the department.
So I just want to let folks know we're actually at time, and this has been a really terrific webinar. I would encourage folks, if hopefully we answered all the questions that people had today for the webinar. If you have any additional questions, please reach out to Empire Justice Center and we can get them to our presenters for today. But I just, on behalf of Empire Justice Center and the domestic violence community at large, I just want to thank all of you today for sharing what you know, for being really thoughtful about the scenarios and giving people a lot of real life scenarios that you could sort of explain what you do and how you do it. So thank you all very much, and be well.
Thank you for organizing this, Amy.
Thank you for having us.
Oh, we're very happy to have you.